Now we're going to return you to our nation's capital, where we just got a big ruling in where the Supreme Court just released a decision on President Trump's tariff authority.
Yeah, this is breaking news. In their decision, they ruled against using Emergency Powers Act to impose tariffs, which undercuts the very foundation of the president's economic plans. You know, we have really followed this story since the very beginning, especially because there's a Vernon Hills company called Hand to Mind. They have learning resources for young children. We've spoken with the owners of that company repeatedly, as this has really bounced around in the court system for quite some time here. And, you know, what they look at is the fact that these tariffs would essentially put them out of business, that the added cost to do business would put small businesses out of commission, essentially. You heard the governor talk about it in his State of the State address just this week, speaking about.
All right, people, welcome back to Dr. John Podcast. Despite narratives of unchecked Trump power, federal judges, including Republican appointees, have repeatedly halted his administration's sweeping actions across immigration, trade, and criminal law. Their rulings have stopped the White House cold, showing that the courts remain a real check on executive overreach, even in a second term. We are witnessing something remarkable, a judicial system that is moving with unprecedented speed to check executive overreach before it can become irreversible. Federal judges are issuing instant orders that take effect within hours or days, not the typical months or years of litigation that most people associate with court cases. They are covering entire affected populations nationwide, not just the specific plaintiffs who filed the lawsuits.
That very aspect of the small businesses, I could tell you that just this week, I also spoke with the founder of agnet.com.
Okay.
And he is a 7th generation farmer in central Illinois, and he talked about it. You know, obviously, they look at it from a very different perspective, but if you think about the crops that they're harvesting, the imports, the exports, from that standpoint, you know, also talking about, I mean, he said this was one of the biggest issues that he has had to face in his time now running his family's company. And I asked him, like, okay, 7 generations, look at what those who came before you had to deal with. Was this the worst? And he was like, without a doubt, this has been one of the trickiest situations for them.
All right, we have our expert on the line, Ross Mack, economist, is going to join us now. Ross, first, let's start with, what is your reaction to this big-time decision by the U.S. Supreme Court?
They are sending a consistent message across different jurisdictions and different legal contexts that the executive branch has limits, and those limits are enforceable. The public conversation about Trump's second term has largely focused on what he wants to do, the policies he wants to implement, the changes he wants to bring about. But what has received far too little attention is what happens when those policies hit the wall of judicial scrutiny. When a federal judge in Boston issues an order that blocks the termination of a humanitarian program affecting more than 10,000 people, that is not a minor procedural hiccup. When a specialized trade court rules that the administration's emergency tariff authority does not exist, that is not an edge case that gets quickly overturned. When appellate courts unanimously reject the claim that a president has blanket immunity from criminal prosecution, that is not a technical dispute.
Well, I was trying to actually see exactly what happened. I was watching CNBC, and I know they were saying, you know, it's a 170-page document, and therefore they actually got to go through it kind of line by line. But right now, I'm actually trying to see, I think, you know, when it's all said and done, it's like it can potentially have adverse impact on the market. But I think, you know, if the Supreme Court is to uphold it, I think that, you know, it's a function of how difficult is it to contain inflation, right? I think this is a function of who actually takes on these price hikes. Is it the foreign producers or is it the end consumer here? And I think, you know, so far we've been seeing inflation be extremely persistent. And as a result, the American consumer actually has been really bold, you know, holding that cost. And, you know, as we all understand, the cost of living has been extremely high as of recent.
Yeah, it's so hard because businesses can only boost their prices to offset that so much. when you have people who are already feeling cash strapped. Ross, over the last few days, even yesterday, the stock market.
These are fundamental constitutional questions being answered with remarkable swiftness and remarkable consistency by federal judges who are doing exactly what the founders envisioned when they created an independent judiciary. They are saying to the executive branch that the law matters, that the Constitution matters, that you cannot simply do whatever you want because you believe you have the power to do so. The pattern has become unmistakable. Time after time, the Trump administration has moved aggressively on a policy front, believing that it had the authority to act unilaterally. Time after time, federal courts have issued orders that stopped those actions in their tracks. And time after time, the administration has had to back down. Not because it wanted to, not because it conceded that the courts were right on the underlying policy questions, but because the alternative was contempt of court and a constitutional confrontation it was not willing to have.
Was read all day. The last few days ahead of that, we saw some volatility there. But look, right now on your screen, we're showing, there was some green popped up here. How do you think the day is going to play out?
Well, I think it's important that we understand everything is relative. If you look at the stock market, it's still extremely it's been doing extremely well, right? I think, and this really bodes to the fact that we're in a K-shaped economy, right? Where the people that own assets are doing well, where the people that don't are actually feeling the true impact of higher inflation, right? As you showed Dow Jones just crept over 50,000, which was monumental. And as you can see, it's not far off. And so I think that the stock market has obviously been extremely resilient, right? I think the first time we talked about these tariffs and Liberation Day was a year ago, and that's when we first saw the pain. And since then, the market has truly just shrugged it off. And so I think to anybody that's an investor,
what we are seeing is a stress test of American democracy happening in real time, and the judiciary is passing that test. The courts are moving quickly. They are issuing strong rulings. They are making it clear that the executive branch operates within boundaries, and those boundaries are enforceable. The president cannot simply ignore court orders because he disagrees with them. He cannot claim sweeping immunity from prosecution for actions taken while in office. He cannot revoke legal status from tens of thousands of people on a whim. He cannot impose global tariffs using a statute that does not authorize what he is doing. This is the story of how the system works when it works the way it was designed to work. It is the story of judges doing their jobs.
Don't, look at a day like today in a microcosm and say, oh, now let me be risk off. I think, everybody should always remain long term because the market already has digested and said we are able to live with tariffs. Now, in the event the Supreme Court is to reverse it, that could very well be good in the short term for the stock market. But nonetheless, we got to look at this on a long-term standpoint. And then you could actually say which sectors are going to do well. And I think that's the one thing that might change. But I think in terms of dollars that's been on the sideline, the stock market, once again, all of the indices are near all-time highs, right? And now if we're saying which sectors may do better than the others, now we're talking about companies who assemble their products, whether it's in China or India, et cetera, whether it's autos, whether it's, devices, electronic devices, phones, computers, et cetera, that might, we might actually see some of those prices come down for the end consumer. But when it's all said and done, I always implore people, be a long-term investor and don't even look at it.
Ross, I want to make sure here that we have been led to believe that the Supreme Court has indeed reversed the decision on tariffs. Are you hearing something different from that?
And it is a story that deserves far more attention than it has received. Let us begin with a case that perfectly illustrates how these judicial interventions work in practice. A case that shows what an instant order actually looks like and what it means for the real people caught in the middle. The Family Reunification Parole Program was created as a humanitarian initiative, a way for people from certain countries to come to the United States temporarily while they wait for family-sponsored green cards to become available. Tens of thousands of people at any given time are in various stages of this program. People who have gone through a legal process, who have received approval to be here while they wait, and whose lives are built around that legal status. They have jobs, they have homes, their children are in American schools, their entire existence in this country depends on maintaining that status. When the Trump administration moved to terminate the program and revoke the status of more than 10,000 people who were benefiting from it, it was not making a minor adjustment to immigration policy. It was threatening to upend the lives of thousands of families who had done everything the government asked them to do, who had followed the legal process, who had been told they could be here while they waited for permanent status. And the administration did not give them time to figure out what to do next. The terminations were set to take effect within days, leaving these families no time to find alternative legal options, no time to make arrangements for what would happen if they were suddenly forced to leave the country where they had built their lives. This is where the court stepped in. A federal judge in Boston received the legal challenge and immediately recognized the stakes involved. The judge understood that if these terminations were allowed to take effect, while the courts considered whether the administration actually had the authority to revoke this status, the harm would be immediate and irreparable. 10,000 people would lose their legal status and face removal from the country before any court had a chance to determine whether that removal was lawful. The judge also understood that the normal pace of federal litigation, the months or years it typically takes for cases to work their way through the system, would be far too slow to prevent this harm. So the judge issued what is known as a temporary restraining order, a mechanism designed precisely for situations where immediate action is needed to prevent irreparable harm. The order was not a final ruling on whether the administration's termination of the program was legal. That question would require more briefing and more argument before a final decision could be made. But the order did something extraordinarily important. It put a pause on the terminations for 14 days, giving the court time to examine the legal questions more thoroughly while keeping these families in their homes and maintaining their legal status in the meantime. The order was instant, taking effect the moment it was issued. It was nationwide, covering every single affected beneficiary of the program across the entire country, not just the specific families who had filed the lawsuit, and it was binding, meaning the administration had no choice but to comply or face contempt of court. The administration was forced to stop the terminations cold, to tell the affected families that their status would remain in place while the courts considered the legality of what the administration was trying to do. This is the reality of judicial intervention in the Trump era. It is not theoretical. It is not abstract. It is federal judges seeing an imminent harm and moving with extraordinary speed to prevent it. The administration did not want to pause these terminations. It had made a policy decision and wanted to implement it immediately. But the court said no, and the administration had no choice but to comply. The pattern we see here, aggressive executive action, swift judicial intervention, and reluctant but real compliance, has repeated itself across multiple policy areas in Trump's second term. Consider what the tariff situation tells us about the limits of executive power. The Trump administration imposed near global tariffs using emergency powers, claiming that a trade deficit constitutes a national emergency that allows the president to take sweeping economic action. The tariffs were designed to reshape American trade policy dramatically, to send a message to trading partners that the United States would no longer tolerate what the administration viewed as unfair trade practices. They were a central part of the administration's economic strategy, a fulfillment of campaign promises that had been made for years. But when a specialized federal court called the Court of International Trade examined the legal basis for these tariffs, it found serious problems. A 3-judge panel ruled that the International Emergency Economic Powers Act, the statute the administration was relying on for its authority, does not actually authorize the president to impose sweeping tariffs on nearly all countries. The Constitution, the court noted, gives Congress authority over foreign commerce, and the statutory language of the Emergency Powers Act simply does not extend to the kind of broad tariff authority the administration was claiming. This was a devastating ruling for a core part of the administration's economic agenda. The tariffs were supposed to be a signature achievement, a demonstration that Trump was serious about trade in ways that previous presidents had only talked about. Now, a federal court was saying that the entire legal mechanism behind those tariffs was invalid. The administration could not simply continue imposing the tariffs as if nothing had happened. The court's ruling created immediate legal uncertainty about whether the tariffs were enforceable, and businesses and foreign trading partners began making decisions based on the assumption that the tariffs might not survive legal scrutiny. The administration had to begin walking back parts of its tariff regime, reducing certain measures and delaying others while it figured out how to respond to the court's ruling. This was not a voluntary retreat. The administration had made the political calculation that the tariffs were popular with its base and worth the economic disruption they caused. But the court's ruling changed the calculation. The legal authority the administration was claiming did not exist, and that meant the tariffs could not stand as they were. Even as the administration appealed the ruling, it had to make practical changes on the ground. Some tariffs were reduced, others were delayed. The administration tried to salvage what it could of its trade strategy while the legal battle continued, but the retreat was real and consequential. The president, who had promised to use his authority to reshape global trade, was forced to acknowledge, in practice if not in words, that his authority had limits that the courts were willing to enforce. The Abrego-Garcia deportation case adds an even more striking dimension to this pattern of judicial restraint, a dimension that reveals something fundamental about how the administration operates when it pushes too far. Kilmar Armando Abrego-Garcia was an asylum seeker whose case was pending in federal court. A federal court had issued a specific order saying he could not be removed from the country while his case was pending. This was a binding legal order, the kind of order that the executive branch is supposed to follow just as everyone else must follow court orders. But the administration deported Abrego-Garcia to El Salvador anyway. The deportation happened in apparent violation of the court order, a direct challenge to the court's authority that went beyond mere disagreement with the underlying legal question. The administration was not just arguing that the court was wrong about the law, it was acting as if the court's order simply did not matter. This is where the story takes a particularly significant turn. When the case reached the Supreme Court, the administration's own lawyers had to make an extraordinary admission in their court filings. They conceded that the government had wrongly deported Abrego-Garcia in violation of the lower court's order. Let that sink in. The lawyers representing the president had to go before the Supreme Court and acknowledge that the executive branch had violated a court order. This was not a procedural technicality. It was not a minor error that could be corrected with a simple filing. This was an admission that the administration had done something it was legally prohibited from doing. The admission is extraordinary in part because of what it reveals about the administration's enforcement posture. The administration had been so aggressive in its immigration enforcement efforts, so determined to remove as many people as possible, that it was deporting individuals even when courts had specifically ordered them not to be deported. The enforcement machinery was moving so fast that it was ignoring judicial orders, and this was happening not at the margins but in cases that involved binding federal court orders. The Supreme Court's handling of the case affirmed the lower court's authority and underscored that even presidents and their executive agencies must comply with court orders. The ruling was a significant loss for the administration, not because of the specifics of the Abrego-Garcia case, but because of what it signified about the relationship between the executive and judicial branches. The administration could not simply ignore court orders it disagreed with. It could not deport people in violation of judicial rulings and expect to get away with it. The courts would enforce their orders, even against the president. This case matters not just for what it says about immigration enforcement, but for what it says about the broader constitutional structure. The president is not above the law. The executive branch does not have a blank check to do whatever it wants in the name of enforcement. The courts have the authority to issue binding orders, and the executive branch is obligated to follow them. When the administration violated that obligation, its own lawyers had to admit it, and the Supreme Court made clear that such violations would not be tolerated. The immunity ruling from the D.C. Circuit Court of Appeals represents perhaps the most constitutionally significant judicial intervention of the entire Trump era, a decision that goes to the heart of presidential power and accountability. The ruling came in the context of the January 6th federal criminal case, where Trump was arguing that a former president has absolute immunity from criminal prosecution for any actions taken while in office. The argument was sweeping. It did not claim limited immunity for specific official acts. It claimed blanket immunity for everything a president does while holding office. This would have been a radical expansion of presidential power, a transformation of the presidency into something the founders never intended. If presidents could not be prosecuted for anything they did while in office, they would have no real accountability for the most serious abuses of power. They could commit crimes with impunity, as long as those crimes were committed in the context of their official duties. The transfer of power, the most fundamental mechanism of democratic accountability, would be undermined because presidents could claim immunity for for actions taken to prevent that transfer. The D.C. Circuit understood the stakes. In a unanimous decision, 3 judges, including 2 appointed by Republican presidents, rejected Trump's claim. They wrote explicitly that no president has blanket criminal immunity for acts committed in office. They went further, stating that they could not accept the claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. The specificity of the language matters. The court was not just rejecting a legal argument, it was affirming that the peaceful transfer of power, the cornerstone of American democracy, cannot be undermined by presidential claims of immunity. The decision was fast-tracked specifically because the court recognized the time pressure involved. The January 6th case needed to move quickly. The public needed to know whether a former president could be held accountable for actions taken in connection with the election. Normal appellate timelines, the months or years it typically takes for cases to work through the system, would not serve the public interest in this situation. The court accelerated its review, issuing a clear and unanimous ruling that made the boundaries of presidential power explicit. The immunity ruling is important not just for what it says about Trump, but for what it says about the presidency generally. The court established a principle that will apply to future presidents as well. No president can claim blanket immunity from criminal prosecution. No president has unbounded authority to commit crimes in the service of political goals. The transfer of power, the mechanism that allows American democracy to continue from one administration to the next, cannot be undermined by presidential claims of immunity. The significance of this ruling cannot be overstated. The court was not engaging in partisan politics. It was interpreting the Constitution in a way that protects the fundamental structure of American government. The president is not a king. The president is not above the law. The president can be held accountable for crimes committed while in office. These principles are now established more firmly than ever because of the D.C. Circuit's ruling. Let us now connect these individual rulings to the broader pattern they reveal, a pattern that tells us something important about the state of American democracy in the Trump era. In every one of these situations, the family reunification program, the tariffs, the deportation case, the immunity argument, the administration pushed past what it believed were the limits of its legal authority. It encountered a federal court that was willing to issue a binding order saying no, and it had to at least partially back down in response to that order. The speed of the judicial responses is itself notable. These were not slow-moving cases that took years to work through the system. The Boston temporary restraining order took effect immediately and covered the entire affected population within days of the legal challenge being filed. The Court of International Trade decision came relatively quickly after the tariffs were imposed. The D.C. Circuit immunity decision was fast-tracked, specifically because the court recognized the time pressure. The courts were moving at a pace that reflects their understanding that the alternative was allowing irreversible harm to occur. The willingness of courts to move quickly, to issue emergency orders and fast-track rulings is itself a judicial message about the severity of the situation. Courts typically do not move this fast. They typically give deference to executive branch decisions, especially in areas like immigration enforcement, foreign policy, and economic policy, where the executive has significant latitude. But when courts start issuing rapid-fire orders and emergency rulings that halt specific executive actions, it signals that they have determined the executive is operating outside the bounds of its authority in ways that cannot be tolerated while normal litigation proceeds. The pattern of these interventions across immigration, trade, criminal immunity, and deportation policy simultaneously suggests that multiple courts in multiple jurisdictions are reaching the same basic conclusion independently. This is not a single judge in a single court imposing a partisan agenda. This is a consistent judicial response to consistent executive overreach. The executive branch is pushing past legal limits in multiple policy areas, and federal courts are correcting it in each area. There is a second layer to what these rulings do beyond their immediate legal effect. They directly undermine the political brand that Trump has cultivated, the image of a president who acts decisively and does not wait for permission. Trump's political identity depends on the appearance of action, of getting things done, of following through on promises that previous politicians only made. The tariffs were an expression of that brand. The immigration enforcement actions were an expression of that brand. The immunity argument was an expression of that brand. The idea that a president should be unconstrained in doing what he believes is right. When courts issue orders that say stop, back down, restore what you took away, and do it now, they undermine that brand. They demonstrate that the dramatic moves were not actually within the president's authority. They show that the president's power is limited, that he cannot simply do whatever he wants. The tariff retreat is particularly significant in this regard. The tariffs were supposed to be one of the signature achievements of the second term. Having a three-judge panel tell you that the legal mechanism you used for them does not authorize what you did creates real political costs. The administration has arguments in response to these rulings. On the tariffs, it argues that the Court of International Trade misread the scope of the statute. On the immunity ruling, it notes that the Supreme Court later established some presidential immunity for official acts. On the deportation case, it argues that the concession was about a procedural failure rather than a general policy. On the family reunification program, it argues that the temporary restraining order does not resolve the underlying legal question. These are real arguments with varying degrees of merit. But here is what those arguments do not change about the practical reality. The family reunification termination stopped. Parts of the tariff regime were reduced or delayed. The administration's lawyers conceded in court that a deportation violated a court order. The immunity argument was fundamentally restructured. These are not theoretical outcomes. They are documented facts about what happened, about how the executive branch was constrained in real time by courts issuing orders that the administration could not safely defy. The courts are still working. The system is still functioning. When judges decide to move quickly, when they decide that the situation in front of them cannot wait for normal litigation timelines, they are still capable of putting a hard stop on executive actions that exceed legal authority. This is the story that does not get enough attention in how people talk about Trump's second term. The courts are stopping him, not occasionally, not in isolated edge cases, but repeatedly, consistently, across multiple policy areas, with the kind of fast-moving orders that take effect within hours or days. Federal courts have issued a series of immediate and binding orders that have forced the Trump administration to pause or scale back specific actions across immigration, trade, and criminal law. A Boston judge issued an instant nationwide temporary restraining order blocking family reunification program terminations. The Court of International Trade ruled the tariff emergency powers were exceeded, and Trump quietly walked back parts of the regime. The D.C. Circuit unanimously rejected blanket presidential immunity in a fast-track decision. The Supreme Court affirmed that even presidents must obey court orders after the administration conceded it wrongly deported a man in violation of an existing judicial ruling. These are not slow-moving theoretical debates about executive power. They are specific, documented moments where the court said no and the administration had to comply. Not because it agreed, not because it wanted to, but because the alternative was contempt of court in a constitutional confrontation that even this administration calculated it could not sustain. The image of a president who is unconstrained and can do whatever he decides is the right thing to do is being tested repeatedly and specifically in federal courts across the country. And the courts, moving faster than most people expected them to, are producing a record of rulings that says something very clear about where the limits of executive power actually are. You can push hard. You can push past what previous presidents tried. But there are judges who will issue an instant order when you push past what the law allows. And when they do, you back down. That is the story of Trump's second term so far. And it is a story that matters far more than most people realize.